Hi everyone, in this third instalment of the series on reasonable adjustments, we're talking about another specific case scenario in relation to the reasonableness of putting adjustments into place for disabled employees. We're going to follow the same methodology as the previous video in looking through the factors that the Equality and Human Rights Commission recommend we look at when discussing the reasonableness of adjustments. Now in this case it's something which has only arisen with me for the first time in giving advice to employers, and that's the conundrum of displacing employees. So again, it's a live example. In this case we have an employee who, because of a physical impairment, can't travel significant distances. A little bit similar to the last video in that sitting for prolonged periods in the same position causes significant distress and discomfort for the employee. So what they have suggested is that they can travel a maximum of 15 minutes to work. They work for a retailer, so in terms of the premises of the employer, there are probably 5 possible options in terms of where he can go within a reasonable travelling distance, but the substantive role is actually delivered from somewhere that's around 40 minutes travel. So the request for a reasonable adjustment in this case is to be redeployed to another centre, another retail premises, which would be a shorter travelling distance. There is no doubt in those circumstances that that particular step will be effective in preventing the substantial disadvantage. The problem is when we apply this to this specific employer in this specific scenario, we arguably come up with a result which is that the adjustment is not reasonable at this particular time. The practicability of the step is not really in question, so the employee is suggesting that he will perform exactly the same role in another premises. There will be no need to vary the terms and conditions of employment because the working hours will stay the same. We are purely talking about the commute before and after work, which would reduce the stress, physical stress on the employee's impairment. The issue for the employer in this case is the financial and other costs of making the adjustment and the extent of any disruption caused, because in this case the role that the employee wants to perform in another premises is not available. It's well established case law that the employer does not have to create a vacancy where one does not exist, but this is a specific question about displacing other employees. So the adjustment suggested has been quite clear in stating that we have 5 people at 5 other premises undertaking the same role. Is it reasonable for us to displace one of those employees, move them to perhaps the employee's centre and swap them round essentially? We have very limited case law on that point, so the employer's argument is, well, that is not a step that we believe we should have to take because of the implications for other colleagues. We have very high performing premises elsewhere, we have very established staff, we have good relationships between the the manager, which is the role that the employee wants to perform, and their team, and the disruption caused by displacing that person and potentially putting them to detriment by moving them elsewhere would not be justifiable. There is one case that we've come across in the past where it was actually deemed reasonable for an employer to swap jobs between a disabled and a non-disabled employee. That was very fact specific in relation to the duties being carried out within the South Yorkshire Police Force, and I'm quite comfortable that we can distinguish those circumstances in this case. The employer is under an obligation, however, to demonstrate that that disruption would be legitimate and significant, and in this case we would draw on the characteristics of the managers in other posts and the team that they are managing to demonstrate that there will be too much disruption at those premises by swapping one employee in and out. Now that doesn't mean we can't implement the adjustment if a vacant post arises, but otherwise, unless and until that happens, we are not going to be able to implement that adjustment, and we will conclude it's not reasonable. In relation to the other elements of the test, the employer is very significant in terms of cost and resources. You can tell that by the number of premises they operate. There is no other financial or other assistance that is needed to make that adjustment because it's the physical time spent in the vehicle travelling. The size of the employer again is significant, so that's not an issue. So this is a case really where we're focusing on one particular factor that the EHRC have suggested, and one which on the face of it is actually possible to implement. The difficulty is the disruption that it would cause for other staff in making that change, and at this stage we would conclude that adjustment is not a reasonable one to make. As I say, these are very fact specific. We need to go into great detail in each case in assessing the particular adjustment, the employer's requirements, the employee's needs, cost and other effectiveness implications, and those on other staff as well. If you do have anything that you need to take advice on this front, or anything relating to employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.